against Oovee Ltd. Appeal hearing.
Yes, Mr Tanner.
My Lords, two preliminary matters before I launch into submissions.
I thought
Two preliminary matters before I launch into submissions.
right. I thought we were told this case was settling. No.
My Lord, it is settling, and that is one of the preliminary
Right.
matters. So the first preliminary matter, and I think I need to take this first, is that although there was an invitation in our skeleton argument that the appeal be heard in private, that is not pursued.
Not pursued. Right.
The appeal is, of course, on a matter of general principle in any case,
Right.
and many matters in this dispute are no longer confidential, and my learned friend and I will, I think, avoid referring unnecessarily to such matters, if
Yes.
any, as remain confidential. So we will proceed on that basis, and I think that is
Right. So this is a public hearing.
public hearing. My Lord.
Right.
I should mention that in an interim hearing in this appeal, this issue came up, and a different panel of this court took the view that it should certainly not be in private for reasons that seem to me to be very cogent, and that is one of the reasons why this is.
Yeah, well, we're dealing with a hard-edged point of law, which is not dependent on the facts.
Indeed, my Lord. Yeah. The next point is, and I'm sorry about the confused messaging, but the position is that the parties have agreed a settlement of this case, of the whole dispute, but one person who has to sign the documentation has not yet signed it. So I regret to say, in the circumstances, I think we need to continue with the appeal in case it doesn't get signed. But my learned friend and I are going to jointly ask your lordships not to render a judgment for 24 hours following this appeal, and not to make it, not to announce a decision on the appeal.
Well, I mean, if you're going to argue the appeal,
yeah.
then even if it settles, we have a discretion whether or not to give a judgment.
Indeed, my lord, and if it has settled by the time my lords give a judgment, that's not a problem for the parties, and it would be of some benefit, I think, to practitioners to actually have this point resolved one way or the other, because it is obviously a point that may occur again.
Yes.
So
you're not suggesting that we don't give judgment at all. You're just saying suspend it for 24 hours.
Yes, my lords. I think that's what my learned friend
Right, I think we're set up now.
Marlon, I'm so sorry again for the trouble that we've
Don't worry.
unwittingly caused. So, my lord, this is really a question of statutory construction.
Yes.
The construction of Section 42 of the Arbitration Act. Parliament could have granted the power that Oovee says it did. Equally, it may not have done, and it's necessary to determine what it actually did. That construction needs to take into account the purpose and the context of the provision and basic principles of statutory interpretation, as well as, of course, the wording of the provision.
Yes.
And such case law as there is that has touched upon the point. And I propose to take matters in this order. I propose to look first at the purpose and context and general principles of statutory interpretation that should bear on the question. Then to look at the case law. Then to consider why we say the judge went wrong. Then to make some comments on my learned friend's skeleton argument. And then to sit down.
Right.
So starting with the purpose and the context. The issue is whether Section 42 is to be interpreted as empowering the court to make an order to enforce a peremptory order of a tribunal without satisfying itself that the tribunal has jurisdiction, and in particular where it's claimed that the referral to arbitration has been terminated by acceptance of repudiation.
Well, it's not plain, though, is it? Judge said he was unable to see the strength of the case. He was unable to determine that.
My lord, he said that he was unable to resolve
Yes.
That at that hearing.
Yes.
But he certainly did not satisfy himself.
No, he didn't. But you said where it's plain, and it isn't plain.
I didn't intend to say plain.
Oh.
I apologise. My diction doesn't seem to be working terribly well this morning. Without satisfying itself that the tribunal has jurisdiction,
Yes.
were the words I intended to use, as stated in my skeleton argument. Not about anything to do with whether it's plain or not. What I would say, my lord, and I'll be coming to this later when discussing the judge's reasons, is that it's perfectly possible in a case where a frivolous point is, where there's a frivolous challenge to jurisdiction, it is of course open to a court to make a summary decision that the challenge is frivolous, it's fanciful, in the same way as the court can deal with any other fanciful point and frequently does. And of course one relies on practitioners as well not to take frivolous points, but if they do, then that can be disposed of. But in my submission, where the challenge is not frivolous, then it is our case that the tribunal must satisfy itself.
The court must satisfy.
The court must satisfy itself that the tribunal actually had jurisdiction.
Well, if, as in this case, the arbitrator has decided he's going to rule on his own jurisdiction, and will perhaps need to find facts for that purpose, isn't there a risk of conflict between what the court decides on the facts and what the arbitrator decides on the facts?
Well, my lord, the court can do one of two things. It can decide the issue as to jurisdiction, or it can say, we are not satisfied, I am not satisfied, in the case of a sole judge, that the tribunal has jurisdiction, and in those circumstances, the penal powers of the court cannot be invoked. So the court doesn't have to decide, although it can decide. And my learned friend says, and perhaps rightly, that if the court does decide it, it is then res judicata, and the arbitrator then has to follow. But in my submission, there's nothing wrong with that happening. The power of the arbitrator to decide his own jurisdiction is not an exclusive power. He certainly does have that power, and he also has the power to defer that decision until he decides on the merits. Those are powers that are granted by the Act, but they are not exclusive. In certain circumstances, and in my submission this is one of them, where the matter comes before the court, it is open for the court to rule on it.
Can I just ask you this? You said the court doesn't have to decide whether the tribunal has jurisdiction. That's one of the options it has, but it doesn't have to do that. But the point on which you've got permission to appeal is whether the court must decide the arbitral tribunal does indeed have jurisdiction before making any Section 42 order. So if your formulation now is that the court need not decide, you lose this appeal, don't you, on the only point for which you've got permission?
No, my lord, but perhaps I can qualify what I just said.
Right.
The court can reject a claim for a peremptory order without deciding that the arbitrator did not have jurisdiction. But if the court is to grant the peremptory order, then the court must decide that it has jurisdiction.
I see.
So it does operate in that direction.
Yeah.
But in my submission, that is entirely legitimate. And whilst there are the circumstances in which one can come to the court are limited, once the matter has come to the court on the basis of a claim under Section 42 in this instance, then the court has power to decide any issue that arises as a result of that application.
Which do you say the judge should have done in this case? Refused an order or investigated the question of the tribunal's jurisdiction?
Well, that would be a matter of his discretion, first of all, I should say. And it's one that one could decide either way. In my submission, in this particular case, given the timescale with which the judge was operating, the better course would have been to refuse to grant a peremptory order, having regard to all the considerations in this case.
Yeah.
If it had come before the judge significantly earlier, so that there was actually time before the arbitrator would be giving a ruling, then it might have been otherwise. But this would be a kind of case management issue as to what's the best thing to do in the circumstances to aid the efficient resolution of the matters and avoid prejudice and so on. One of the considerations in this case is that expenditure had been incurred on the case by Oovee over a considerable period of time, and in the wider dispute in a considerable number of other matters, and the extra expenditure that Oovee would incur on going to the arbitration hearing would not be so severe and would certainly be a small amount compared with the amount of security that was being ordered to be paid. In those circumstances, it was not so critical that a peremptory order needed to be made. So taking all these considerations together, in this particular case, in my submission, that would have been the better course would have been just to decline to make the peremptory order and leave matters to the arbitrator to decide jurisdiction.
So in the circumstances of this case,
in the circumstances of this case,
your point of law is that it's sufficient to defeat the court's jurisdiction to make a Section 42 order if there's merely an arguable challenge to the arbitrator's jurisdiction?
My Lord, yes.
So as I understand it, Mr Turner, your case is that if an arbitral tribunal has decided, say, to rule on its jurisdiction later, let's say, which is something that happens in arbitrations, certainly sometimes, if not often. I'm not qualified to say if it's often, but it certainly seems fairly often to me. If this power is to be enforced, to be used in the context of an arbitration, the only way that order could ever be made would be for the court to then rule on the jurisdiction that it positively exists.
My Lord, yes. But in my submission, that's not an unreasonable result by any means. In a case where the arbitrator anticipates that it may well be a peremptory order may well be required, it would be desirable for the arbitrator to rule as soon as practicable on a challenge to jurisdiction, and not to leave it until later. And so actually it would be a good thing that that requirement should be in place, in my submission.
But there are many cases in which the issue of the jurisdiction of the tribunal is bound up with the merits of the substantive dispute. There's a claim that the agreement itself is void for some reason.
There are some cases where that is true. I'd hesitate to say many. Of course, the arbitration agreement is a separable element, so a separable agreement. So the mere fact that the agreement in general is invalid or has been can be avoided doesn't necessarily mean that the arbitration.
No, but one often gets cases where, for example, the dispute is that one party says, I'm not a party to this contract, to the matrix contract, and therefore not a party to the arbitration agreement.
Indeed, and that would be a very good case for saying that they shouldn't be subject to a peremptory order. They're saying, well, I never agreed to any of this. This person has no authority to be ordering me to do anything, and it's quite unreasonable for the court to be threatening to send me to jail for disobeying something that no one has any authority to order me to do. Or this particular person has no authority to be ordering me to do this. In my submission, that's another example that exemplifies the undesirability of the court being able to make an order with penal consequences when it's not satisfied that that order was made by a tribunal having any jurisdiction. Conversely, of course, if the court is satisfied, then there's not a problem. Then the peremptory order can be enforced by the court's machinery and with the court's authority. So, my lords, the purpose of the power granted by Section 42 is to assist the proper functioning of the arbitral process, and in a sense that might be quite obvious from its place in the legislation, but is also supported by paragraph 212 of the report on the arbitration bill, the Departmental Advisory Committee's report, which is frequently referred to in arbitration cases, as I'm sure my lords are aware. My lords, I mentioned this. I don't think I actually need to trouble my lords to look at that right now, because I think it's pretty clear. But the purpose of aiding the arbitral process is no longer extant if the process has been terminated or was never validly started. And in my submission, the section should not be interpreted as conferring a power that exceeds its purpose, particularly in circumstances where the exercise of the power may have draconian consequences. So in general terms, looking at it on a purposive basis, in my submission, that consideration is one that militates in favour of the more limited scope that we submit. The next point I want to make is that the whole system and the process which is assisted and the power itself are grounded on the agreement of the parties. That is the basic justification for granting the arbitrator the power to make a peremptory order and granting the court the power to enforce it. Of course, jurisdiction of an arbitrator is in general exclusively a matter of contract, and there's lots of authority that make that point. I've cited some of it for my Lord's convenience, but my Lords must be so well aware of that I don't think I need trouble you with referring to those cases. And it's reinforced specifically in Section 42 by the fact that it is one of those powers that applies unless otherwise agreed by the parties in Section 42(1). In my submission, the correct approach is to consider that in the absence of an agreement to the contrary, the parties' agreement to arbitration is implicitly an agreement to the power of the court to enforce the tribunal's peremptory orders, at any rate where the parties agree to arbitration under UK law. Arbitration seated in the UK, sorry, I should say, or any other circumstances in which the UK Arbitration Act applies. So it's where the parties agree to arbitration under, or which is governed by the UK Arbitration Act, then they implicitly agree that the UK courts have power to enforce a peremptory order of the tribunal. But where there is no arbitration agreement in force, whether because someone is not a party to it, or because there was an agreement but it's been terminated, or where the matter that's been referred is outside the scope of the arbitration agreement, where there is no arbitration agreement in force, it's not reasonable to presume that the parties have agreed to the court having the power to enforce the orders of the purported tribunal. The arbitrator has no more power than any other person on the street to order someone to do something, and to for the person who asked the purported arbitrator to do that has no right to ask the court to make an order to enforce what that person on the bus said, as it were. And in my submission, this is particularly significant in a case where a repudiation has been accepted, because a kind of underpinning of the concept of acceptance of repudiation is that the repudiating party has effectively made an offer to terminate the agreement by conduct or statement saying we're not going to have anything to do with this agreement, which is accepted by the party accepting the repudiation, and so bringing the contract to an end. So in one sense, it is where the parties have otherwise agreed, as indicated or as qualified in section 42.1. And at any rate, it is a case where it is particularly clear that the parties no longer agree to the arbitration process, or if the agreement has been terminated, there is no longer agreement to the continuation of the arbitration process. Obviously, I accept that it is in dispute whether that is the case. But if the position is that the agreement was repudiated and that's been accepted, then you do have a position that there is no agreement to the arbitrator having any further power to continue the arbitration. And I do on this wish to refer, my Lord, to some passages in
Going to Bremer Vulcan.
in Bremer Vulcan.
Well, I think we're pretty familiar with that authority, but do show us what you want to.
Yes, there was one passage which we highlighted in the bundle. I don't know whether my Lord's got as far as looking at the bundle, particularly given our unfortunate confusing indication this morning. But there was another passage which I mentioned in my skeleton argument, which I will wish to direct my Lord's attention to, and a further passage which may also be of assistance. So if I can start with the passage at the bottom of page 125 in the bundle, on the bottom right-hand corner, page 980 in the report.
Yeah, the bit you want is the first paragraph on 981.
Yes.
Yes.
Which says in quite strong terms, it's picked up again later, but that a party who has accepted a repudiation actually has a right not to be further disturbed by the arbitration continuing. Then there was the passage that we did highlight on page 982, starting at just before C, I think. The paragraph starts at B, and going through down to E.
Yeah.
Which is, of course, a well-known passage from the case.
Yes.
And then there's a passage in the judgment of Lord Scarman, dissenting judgment, but on this point, he took a similar view to Lord Diplock. This is page 143 of the bundle, page 998 of the report, at B to D.
Yes.
And that is certainly another example of the point that where you do have an arbitration agreement and a matter is referred to as to arbitration, the modern view, perhaps if I can call it that, although it's been around for a while, is that that creates a separate contract, specific reference. I don't think anything turns on that in this case, but in terms of the logical analysis,
yes.
that does appear to be unassailable and is well supported by authority. But the other point is just to show that on the sort of basic concept that arbitration agreements are subject to the same principles of formation and termination as certainly termination as other agreements. Lord Scarman agreed with Lord Diplock and the majority. And I mention that because one is, of course, aware that Bremer Vulcan has been the subject of a considerable amount of criticism. But I think on the basic principle that an arbitration agreement can be repudiated and the repudiation can be accepted, bringing the arbitration agreement to an end, that has been common ground.
I don't think it's in dispute in this appeal.
No, my lord, is it?
Facts are in dispute, but the principle is
Yes, indeed, my lord. My lord, the next point I want to make on interpretation of Section 42 is that it's clear that the conditions in Section 42.2 must be satisfied, and if they're not, then the court can't proceed. It's not enough for the court to be able to say, well, the arbitrator thought these things were satisfied, and we're not going to interfere with the arbitrator.
Yeah.
There's no it was a rational decision. The court actually has to be satisfied, and in my submission, that is apparent from the terms and structure of the clause, and it's also apparent from the authorities that those are, if you like, hard conditions that, on any view, must be satisfied. And I've cited relevant paragraphs in authorities at paragraph 49 of my skeleton argument. Again, I'd hope that point in itself is not controversial. But what I do draw from that is that Section 42 of the Act certainly does require some matters to be determined by by the court, not just dealt with as considerations for the court's discretion. Therefore, it's perfectly plausible to treat the question of whether the arbitrator has jurisdiction as also a matter that has to be satisfied, the court has to be satisfied about, not just a matter to take into account in the exercise of the court's discretion.
Yeah.
And then in terms of the specific wording, Section 42.2b is the basis on which Oovee applied to the court, and that requires the permission of the, it requires application to be brought by a party to the arbitral proceedings with the permission of the tribunal and upon notice to the other parties. And in my submission, it's consistent with the purpose of Section 42 to interpret a party to the arbitral proceedings and the tribunal as referring to a party to extant arbitral proceedings and a tribunal that has jurisdiction over those proceedings, not simply to a purported party or an alleged party, but an actual party and an actual tribunal, not a purported tribunal. At the end of the day, I think the wording, the textual interpretation doesn't really resolve the matter. You could see it either way, but in my submission, one has to have regard to the purpose and context of the provision, and some basic underlying principles.
So in that respect, tribunal in this section has a different meaning from the meaning it has in section 67, where it clearly applies to a tribunal whose jurisdiction is the subject matter of the section 67 challenge.
My Lord, yes.
And why should it have a different meaning here?
Why shouldn't it have a different meaning? In my submission, it's perfectly possible to have, for the same word, to have different meanings in the context of different provisions.
And what is it about the context of section 42 that makes it different?
Well, first of all, the purposes of section 42 and the foundation of section 42 as being based on the parties' agreement. And secondly, there's
I'm not sure I'm understanding that, because I thought your earlier submission was really everything that the court can do under the 1996 Act derives from the parties' agreement, either that it should apply directly or that they've agreed to an arbitration agreement which governs it. So that I thought your submission was, which I understood, that in a sense everything that the court is empowered to do under the Act ultimately derives from a consensus between the parties.
I wouldn't say that everything under the Arbitration Act is right. So if a party is asking the court to say, I didn't agree, obviously the court has power to say, yes, you're quite right, you didn't agree. But in terms of the court ordering a person to do something, then that has to be rested, in my submission, on the parties having agreed to that person having power to order him to do something.
Well, suppose there is a challenge to the arbitrator's jurisdiction for whatever reason, either wasn't party to the arbitration agreement or it's been terminated one way or another. And let's suppose that the arbitrator consents to the court deciding that under section 32, which is pretty similar to section 67. That also says that the arbitral tribunal may continue the proceedings and make an award. So in those circumstances, the arbitrator could he not, make a peremptory order, which the court would then have power to enforce under section 42.
In my submission, not, I think.
Well, what would he be able to do under section 32(4), where his jurisdiction is under challenge?
He may continue the proceedings and make an award, but he can't make, in my submission, a peremptory order.
Well, he can do everything except...
Maybe he can make a peremptory order, but the court will not make an order enforcing that peremptory order without satisfying itself that the arbitrator did have jurisdiction. Yeah. Now, I should say, my lord, and I hope this, it is open for me to say this, where the arbitrator has actually determined jurisdiction, then pending if it's not then challenged, or if a challenge is pending, then it may be possible for the court to enforce a peremptory order.
How? You just said that the court must be satisfied that the arbitrator has got jurisdiction.
Well, that I think it is. Again, it's a matter of interpretation of Section 42, and that's not this case. But one can see the argument for saying that, in accordance with general principle, that where a final determination has been made by a tribunal, that is not to be stayed in its effects unless and until successfully appealed. One can see a possible argument to that effect, and I will. There is one of the authorities that does proceed at first instance on that basis, and so I would say that one could treat that situation as differently, where the arbitrator has actually made an award affirming jurisdiction, but that award stands unless and until it is overturned. But if my lords reach the conclusion that that cannot be done, then equally, or that if you like is a if the position is that the requirement in Section 42 is that the court must be satisfied that the arbitrator had jurisdiction, then it applies a fortiori to our case, where there's been no determination.
You said a few minutes ago that the word tribunal in Section 42 means an actual tribunal and not a purported tribunal.
My lord, yes.
And I think you're, to some extent, qualifying that by saying a tribunal means either a tribunal where the arbitrator has decided that he does have jurisdiction, or in the absence of an award by the arbitrator confirming his own jurisdiction, the court is satisfied that he has jurisdiction. Is that the way you put it now?
My lord, that is a possible interpretation.
What is the right interpretation?
My lord, I think the right interpretation is that the court must be satisfied.
Whether the arbitrator's ruled on his jurisdiction or not?
Even if the arbitrator has ruled
Right.
on his jurisdiction. If the court is to intervene and to exercise its authority and to send someone to prison, then the court must be satisfied that the arbitrator had jurisdiction. In my submission, that is the better interpretation.
So your point saying that the arbitrator's award is binding unless or until set aside doesn't apply to Section 42?
My lord, yes.
Yeah. All right, well, I think I understand that.
But if I'm wrong on that, there could be a middle path of saying that where there has been no determination that the arbitrator has jurisdiction, the court may not enforce a purported order of a purported tribunal.
On this middle part, no determination by the tribunal.
Well, I'm sorry.
Where there's the middle path you're suggesting is where there's been no determination by the tribunal.
Yes, my lord.
Yes.
So, other considerations in favour of this, the narrower interpretation that the court must be satisfied that the arbitrator has jurisdiction, is the basic point that Parliament cannot have intended that persons might be exposed to penal consequences from non-compliance with a court order that is based on an order of a person who has no authority to make it, against a person who has no obligation to comply with it, a person who's not agreed that person who made the order has any entitlement to make it.
Yes.
And that, of course, when construing legislation, one assumes that Parliament acts reasonably and one prefers a reasonable interpretation. People, of course, have written books about this in relation to interpretation. And one should try and avoid results which are unreasonable or interfere with fundamental rights. And my lords are very familiar with those principles, and I've noted some examples in my skeleton argument, but again, I don't think I need direct my lords to them. But those really are the considerations of principle or policy, if you like. And I now want to look at some of the cases which have touched on this point.
Yeah, just before you do so, can I ask you this? This Section 42 comes in a section of the Act headed Powers of the Court in relation to arbitral proceedings. And it's followed by Section 43, which deals with securing the attendance of witnesses, which empowers the court to adopt the same procedures as are available in legal proceedings for a party to arbitral proceedings. Do you say that the same applies to those powers, that where, unless the court is satisfied that the tribunal has jurisdiction, it can't exercise those powers because it can't be satisfied that the party is properly a party to arbitral proceedings?
My lord, yes.
And then we get Section 44, which is a much used section, which is for interlocutory relief, or often used for interlocutory relief to support arbitration proceedings involving taking of evidence, preservation of evidence. It's often used for freezing injunctions, matters of that nature. Do you say that those powers can only arise if the court has first satisfied itself that the tribunal has jurisdiction?
Well, my lord, I think in cases of urgency, it might be different. And obviously there's a special provision in Section 44 for dealing matters in cases of urgency.
Yes. Why is it different in matters of urgency? It'd still be, on your case, having a court making orders against somebody who might not have agreed to the dispute being arbitrated by the tribunal, and therefore inferentially to the English court having any powers as the court of the seat.
Yes.
Why is it different on your case?
Simply a matter of considering the purpose and the context. The purpose of that provision is to enable the court to preserve matters in cases of urgency.
And under Section 42, what we're really looking at is an order for security for the claim, which is not very different in kind, is it, from what we used to call a Moreover injunction, freezing order?
Well, in my submission, it is different because there is an opportunity to determine the issue for the arbitrator, and an opportunity for the court to assess whether it is satisfied that the tribunal does indeed have jurisdiction. Furthermore, the wording is really quite different in that in subsection 44.3 provides, if the case is one of urgency, the court may, on the application of a party or a proposed party to the arbitral proceedings, make such order as it thinks necessary for the purpose of preserving evidence or assets. So it contemplates this being done by a proposed party, not an actual party.
Well, both.
And in contrast, subsection 4 says if the case is not one of urgency, the court shall act only on the application of a party to the arbitral proceedings upon notice to the other parties in the tribunal, which is somewhat similar language to that used in section 42. Yeah. And so supports an interpretation that would require the court, if my submission is correct on section 42, to satisfy itself that the party is indeed a party to arbitral proceedings and that the tribunal is indeed a tribunal. As I said earlier, depending on the circumstances, the court may satisfy itself and find in favour of the applicant, or may reject the application either on the basis it's not satisfied, or make a determination if that is correct.
How on earth can it do that? You have a cargo of oil, say, typically, which needs to be detained to be preserved urgently. How can the court investigate before it can make that order whether there is substantive jurisdiction in the tribunal?
Yes,
it's just impractical, isn't it?
Yes, no. If it's urgent, then section 44.3 applies, and in my submission, the court can operate section 44.3 without an investigation of jurisdiction.
So in 44.3, the expression "party to the arbitral proceedings" can include someone who is party to an arbitration where there's a dispute about jurisdiction, without the courts investigating first whether there is or isn't jurisdiction.
Well, yes, I think that's so, and I think the clue, if you like, to that is that it also applies to a proposed party to arbitration. It admittedly doesn't to a person. It doesn't say a person claiming to be a party. That is true.
So your submission on what a party to arbitral proceedings means in section 42.2b, is that it means something different from what party means in section 44.
Yes, my Lord, again, one applies a purposive and contextual interpretation.
Right. Well, I think we've understood what you say Section 42 means. What help are we going to get from first instance cases?
Well, obviously, my lords are not bound by them, but we didn't help the judges perhaps as much as we should have done. The matter did come in front of the judge below as a matter of urgency, and I didn't have quite enough time to get to the bottom of some of these cases. When one actually reads the first instance decisions carefully, they do actually support the view that the court should be satisfied, needs to be satisfied, that the tribunal had jurisdiction.
Right. So your proposition is that the cases show that the court must satisfy itself that the arbitrator has jurisdiction.
Yes.
Right.
Or at any rate, that the judges believed that to be the case, assumed that to be the case, and didn't.
Yes, there aren't any authorities that directly address the point, are there? Even at first.
I wouldn't say directly, in the sense that one party said you've got to satisfy yourself, and the other party said not, and the court said, well, I agree that I have to satisfy myself on this point, and then various other points are matters of discretion. It's not as clear cut as that.
So what help are we going to get from this?
Well, there is a body of view amongst the judges that have looked at cases of enforcement that in favour of satisfying themselves that the tribunal had jurisdiction,
right,
before making a order enforcing a peremptory order under section 42.
All right. Well, you'd better show us what you want to rely on.
So starting with Emmett and Michael Wilson,
Yep.
Which is at tab 9.
Yeah.
And And starting with paragraph 1 on page 193 of the bundle, page 724 of the report. So there were two applications before the court. One pursuant to section 42 for an order requiring the defendant to comply with a peremptory order, and that was made with the permission of the tribunal. And the second pursuant to section 44 of the Act for a freezing order. And then there was also an application before the court which has been brought by MWP. That's the the other applications were brought by the counterclaimant, Mr Emmett. MWP was the claimant under section 67, challenging the award of the arbitration tribunal as to its substantive jurisdiction. Turning then to, going on to paragraph 3, this explains that Mr Emmett and MWP had an agreement under which Mr Emmett would join MWP as a director and shareholder, and they had a kind of quasi-joint venture, quasi-partnership, under which Mr Emmett was to have a 33% profit-sharing interest, and there was an arbitration clause, clause 5.2, and this was an agreement in 2001. The arbitration was commenced by MWP under clause 5.2, and Mr Emmett made a counterclaim. And then matters continued. The peremptory order, which forms the subject of Mr Emmett's application, pursuant to section 42, concerns the step shares, which were shares in a company, Step Cement, which was a significant component of the value of MWP. But by way of an amendment to the counterclaim, an additional counterclaim was added based on an alleged agreement in 2005. And according to this, Mr Emmett said that when he joined MWP, there was an agreement that that 27% of these shares would be held for him. So the dispute as to jurisdiction related to that second counterclaim, it being said that there wasn't an arbitration agreement in relation to that, only in relation to the earlier agreement in 2001. So then the peremptory order was made, and paragraph 6, MWP was directed that the 27% shareholding in the shares be held to the order of the chairman of the arbitral panel, so effectively put into security. And the reasons given was that a central issue in the arbitration surrounds these nearly 10 million shares, which were of substantial value. And they said this is so whether or not Mr Emmett's new proprietary claim to 27% of the shareholding is successful. So that was whether or not the second counterclaim was successful. They said this should be done to in support of the original counterclaim, which related to Mr Emmett's alleged shareholding or share of MWP. And then we go on to paragraph 18. This was the peremptory order was made, and some further reasons were given. the tribunal said it's appropriate in our view to make the order in peremptory terms. The step shares form the most valuable asset of MWP on the evidence. Mr Emmett claims not only the step shares, but also a 33% shareholding of the issued share capital of MWP. And Mr Wilson has been evasive and so on. They were making the order on the basis of the original claim that was made for the shareholding in MWP, irrespective of whether the second counterclaim for the direct shareholding in the step shares was within the jurisdiction of the tribunal, and whether it was whether it had a chance of success and so on. And this was picked up by the by Mr Justice Tier at paragraph 32, where he says counsel for MWP submitted that the tribunal had no jurisdiction in respect to the 2005 agreement concerning 27% of the step shares, and he made the same submission before the tribunal. An award was made. The tribunal decided that it had jurisdiction over that claim. MWP challenged that award under section 67.
Yes.
And the judge says, I'll deal with MWP's challenge to the jurisdiction, but I'm not persuaded that even if it succeeded, it would undermine the peremptory order. Mr Emmett counterclaims a 33% interest in MWP shares, so that was the part of saying that jurisdiction was not disputed, whatever the outcome might have been. Mr Emmett counterclaims a 33% interest in MWP shares. The step shares must be a major part of the value of those shares, and so the peremptory order can be supported as an order in support of that counterclaim. So in saying that, in my submission, Mr Justice Tier assumed that there would have to be jurisdiction over the claim which the peremptory order was supporting.
Well, did he? There wasn't any issue about whether there was jurisdiction over that.
Correct. So if you like, it is obiter. It's not a direct.
Well, put another way, it was common ground there was jurisdiction.
It was common ground. It was common ground. There was jurisdiction.
So what assumptions was he needing to make? He just wasn't concerned with jurisdiction, was he?
Well, he was concerned with jurisdiction on the other claim, and it was put to him, well, you can't give a peremptory order because the tribunal did not have jurisdiction.
Right, and he had to decide that because there was a Section 67 application.
Yes, but he said that won't affect or needn't affect the outcome of the peremptory order application because the tribunal does have jurisdiction which is unchallenged on the other counterclaim. So by saying that, he was assuming that there had to be the peremptory order had to be in support of a matter over which the tribunal had jurisdiction.
So you rely on an unwritten assumption on something that was common ground as authority. Is that what it comes to?
It wasn't common ground that the tribunal had power to make the peremptory order. It was argued that the peremptory order was made to support a counterclaim over which the tribunal had no jurisdiction. And the judge dealt with it by saying, well, I will decide whether the tribunal had jurisdiction, and he did. But even if I were wrong on that, I would still say that the tribunal had jurisdiction to make the peremptory order, and I have jurisdiction to enforce it.
Yes.
So, I mean, it's one of those cases, I think, which is on the borderline between a case which says there are two grounds of my decision, and I decide on this ground, and even if I'm wrong on that, I can decide it on this ground. And whether one says that the second ground that's given for the decision is obiter, or whether it's one of the two grounds of the decision, and therefore part of the ratio decidendi, I think there might be room for argument in that. It doesn't ultimately matter greatly for this court, because this court can, it's not binding on this court, but in terms of indicating the view of an experienced judge in arbitration matters, it has, in my submission, some value. And it also has some value in that, unfortunately, we didn't, as one can see, it's not so obvious, it doesn't scream out of the page at one, but when one actually looks at what happened in that case, one does come to the conclusion that actually Mr Justice Thier said, well, there are two reasons why I can grant a peremptory order. One is because I find, I affirm the arbitration tribunal's decision that it has jurisdiction over the second counterclaim. And secondly, I find that I can make the peremptory order because it supports the first counterclaim over which jurisdiction is undisputed.
Right.
And then if I can pick things up further, at paragraph 46 of the judgment on page 200 of the bundle, page 731 of the report. This reiterates a point that I made earlier, and I think is evident, but is supportive to some extent of our submission.
Well, conditions must be satisfied.
Conditions must be satisfied, and we say this, having jurisdiction is one of those conditions.
Yeah, no, we've understood that's your point.
Yes, and the next point I do want to make, my lord, comes up really at paragraph 62 of Mr Justice Thier's judgment on page 204 of the report, particularly to understand what is going on here. So the judge said, well, I do have a discretion anyway, and considered arguments for and against having a discretion. And but then paragraph 62, it's a paragraph that I think the learned judge below relied on, and my learned friend relies on here, but in my submission it is not, it doesn't actually say what they think it said, because in paragraph 62 the judge says, in what circumstances then might a judge decide not to make an order that a party comply with a peremptory order of the tribunal? And he says, in general terms, the answer to that question will be where such an order is not required in the interest of justice to assist the proper functioning of the arbitral process. See paragraph 212 of the DAC report, which I mentioned earlier. This is not the occasion for a comprehensive list of circumstances, even if one example might be where there has been a material change in circumstances after the peremptory order was made. Now there I would agree that the change of circumstances might result in a condition not being satisfied. So it might be a hard bar to the court making an order to enforce. Or it might be a matter which relates to discretion, and then the court might have to reconsider the discretion because something has changed since the arbitrator exercised his discretion. But then he goes on, another might be where the tribunal has not fulfilled its duty to act fairly and impartially between the parties in breach of its general duty to do so. One might say that conceivably that could be a matter going to discretion, but frankly, if the tribunal has not fulfilled its duty to act fairly and impartially, one might say that's pretty much a reason disentitling the court from making an order to enforce a peremptory order. And then he goes on to say another might be where the tribunal has made an order which it had no power to make. Now, in my submission, that is undoubtedly a circumstance where the court ought not to enforce and has no power to enforce the peremptory.
Well, there's a difference between ought not and has no power.
Yes, I do mean has no power.
You mean has no power.
If the tribunal had no power to make the peremptory order, then in my submission the court has no power to enforce the peremptory order. And I do say that this is an illustration that these considerations that Mr Justice Tier was, or circumstances in which Mr Justice Tier said that the court might not enforce a peremptory order are not necessarily points that go to discretion. They do include points which actually disentitle the court from enforcing.
Although that's not in fact what Mr Justice Tier said.
Well, he said he's listing circumstances in which a court might decide not to make an order enforcing. And he's not differentiating between those where the court decides not to enforce because the court recognises that it does not have power to enforce.
But there are some which wouldn't, even on your formulation, remove the jurisdiction of the court under Section 42. Suppose a tribunal ordered security for costs when under the arbitration rules there was no power to order security for costs. That wouldn't deprive the court of the jurisdiction or power under Section 42, would it? They'd still be parties, arbitral parties, it would still be a tribunal, wouldn't be any jurisdictional question. It would simply be a discretionary question as to whether the court ought to endorse by way of an enforcement order, a peremptory order, which the tribunal had no power to make. It's discretion. It may be a powerful point in discretion, but it's not jurisdiction, is it?
My Lord, in my submission, the court only has power under Section 42 to enforce a peremptory order that the arbitral tribunal has made. And in my submission, if the arbitral tribunal had no power to make that order, then the court has no power to enforce that order.
Because
Now,
it's
you
not
could
an
apply
order,
separate-
it's not a peremptory order made by the tribunal. Is that how you get it into Section 42? If a validly constituted tribunal purports to make an order which is outside its power, then you say that for the purposes of Section 42, that is not an order made by the tribunal.
Well, that would certainly be one way of putting it.
So what's
or
the
it's
right-
not an order made by the tribunal because it has no validity. Rather like Parliament being purportedly dissolved, one might say, if in fact there was no power to dissolve Parliament in those circumstances,
Right.
or suspend
So
Parliament.
peremptory order means a valid peremptory order.
My Lord, yes.
Yes. Right. What's the next case?
So the next case, or cases, are the Popplewell Farm cases.
Yep.
And there are two of them. The first in 2013 was a judgment of Mr Justice Peter Smith.
In tab 17.
Yes.
Yeah. Yes.
And the circumstances are set out in paragraph 2 onwards, page 392 of the bundle. So the arbitrator had actually made an award dissolving the partnership. And consequential upon that, he was supervising the winding up of the partnership.
Yes.
And orders were made by the arbitrator in order to, as he considered, to enable him to deal with the winding up and drawing up of dissolution accounts. And those were not complied with, and so the claimants made an application to the court to enforce the peremptory orders, or peremptory order. In particular, he directed the defendant to deliver partnership financial records, paragraph 4, to Safri Champness, accountants, so that they could proceed. And that was the peremptory order which claimants seek to enforce, paragraph 5. The defendants say Mr. Lee had no jurisdiction to make those orders because they related to accounts, and that was not within his power, they said, under clause 33 of the partnership agreement. They contend that specific provision is made in relation to accounts disputes under clause 9.4 to be determined by an accountant appointed under those provisions. The defendants had also put an issue whether Mr. Lee acted fairly and impartially between the parties in allowing the claimant to raise new issues and produce expert evidence shortly before the hearing, and then going ahead with the hearing in the face of protests. And that was to be the subject of a separate hearing. And then picking it up at paragraph 28 on page 395 of the bundle.
So we see from paragraph 21 that Mr. Lee's arbitration award is challenged on the ground of serious irregularity and on a point of law. So Mr. Justice Peter Smith is dealing with the enforcement of a peremptory order in the context of an award under challenge.
Yes, my lord.
Yeah.
And under challenge on the basis of lack of jurisdiction, see paragraph 6, because the reference there to clause 33 of the partnership agreement is to the arbitration clause.
Yes, so there were two challenges going on. There was a challenge to the power to make the order and peremptory order on the basis that even if his award dissolving the partnership was correct, nevertheless they were saying he didn't have power to order these accounts to be prepared, because he should have followed a different procedure, and presumably
not that he should have followed a different procedure.
So someone else should have followed the
Right. The arbitration clause only covered certain things,
yes,
which did not include an ability to order accounts.
My
classic
yes.
jurisdiction challenge. This is something which isn't within the scope of clause 33, which we've got set out at the...
So there were two separate challenges. The challenges to the general award on the basis of it was unsatisfactory, irregular, didn't give them a chance to be heard and whatever. And then there was a more specific challenge, if you like, saying these orders to draw up these accounts and have this information supplied to those accountants is not a valid order because it's outside the scope of your power anyway. Even if you were right on dissolving the arbitration agreement, it's outside your power. So in dissolving the partnership agreement.
Right, can you take us to the parts of the judgment that set down the principles? It looks to me as though it's paragraphs 59 and 64.
Can I just...
Well, I think you've only got half a day for this appeal,
Yes,
Mr. Turner, and we're already at midday.
Just because... but basically what I do say in relation to this judgment is that the judge certainly considered whether he actually made a ruling on the scope of the arbitration clause and whether the arbitrator had power to direct that these, to appoint Safri Champness and direct that these accounts be made by Safri Champness. That, I think, he does actually go into the agreement.
Yes.
I'm sorry, my lord. I'm a bit lost in this one. If I can just compendiously make my submission on this, so he analysed and came to, he didn't treat it as a matter of discretion as to whether he should proceed with the peremptory order as regards the issue of whether the arbitration agreement, whether the order made was a valid order. He said in relation to that, he actually decided the issue. In relation to the question of the challenge to the award of the arbitrator, he said, well, the general principle is that if you're appealing from something, unless you it's not stayed, and unless you get an order staying it, and until you have your appeal and it's decided. And on that basis, he said, well, I'm going to treat the award as being in force. And that was the point we touched on earlier, as to whether one adopts a middle position or not. That was the approach that Justice Peter Smith adopted. He said, well, arbitration is a bit like court proceedings in that respect, but he may have been wrong on that. It may be that he shouldn't have done it that way. But that's what he did. So to the extent that he did that, and if one thinks that this is an all or nothing point, then that you might regard that authority as being against me. On the other hand, it is for me, for our argument, on the principle that he did satisfy himself that the arbitrator's power extended to these accounts. And then the final case is the Pearl Petroleum one. And, sorry, there was a further judgment of Sir William Blackburn in the case, and the relevant paragraphs are paragraphs 56.
66.
56.
56.
On page 420.
Yeah.
And 57. Where the judge there said I needed to satisfy myself that in making his directions, Mr. Lee had not proceeded on some wholly mistaken basis, or the exercise by him of his power to make the directions would not fatally undermined in some fundamental respect. So not very clear language, it's fair to say, but again, he seemed to think that he needed to consider the justification. And then finally, Pearl Petroleum, in some senses the clearest one, because on page 436 of the bundle, he said there were three issues. Issue one, and this was Mr. Justice Burton. Issue one, was the peremptory order properly made within the jurisdiction of the arbitrators vested in them by Section 41 of the 1996 Act and Article 25 of the LCIA rules? And therefore, does the court have jurisdiction to make an order under Section 42 of the 1996 Act? There were two sub-issues. Was it a requirement of the making of the peremptory order that respondent failed to comply with in order to do something necessary for the proper and expeditious conduct of the arbitration? And if so, was that its purpose? And B, was the respondent given the opportunity to show sufficient cause for non-compliance before the making of the order? So in my submission, that was a clear statement that you have to satisfy that. not a matter of discretion. And then issue
Mr Akins, we don't need to trouble you. We will give a judgment in due course, if you haven't settled by the time we do that, we will make an order. If you have settled, then obviously we won't. Thank you very much.